Mr. Jones here?
Yes, he is, Your Honor.
He's in the foyer.
Oh, all right. All right, back on the record in the Simpson matter. Mr. Simpson is not present before the court. Three of his counsel, Mr. Shapiro, Mr. Cochran, Mr. Bailey, are present. People represented by Ms. Cheri Lewis, and present on behalf of the subpoenaed witness is Counsel Carl Jones. Good morning, Counsel.
Good morning, Your Honor.
Good morning.
Mr. Jones, you have a motion to quash the subpoena for Marguerite Simpson Thomas.
We have, Your Honor. We are moving to quash the subpoena based on the outrageous manner in which the service took place, activities which we feel should shock the conscience of the court, and/or because the witness has no relevant material testimony to offer. You have been presented with two sets of facts. Both cannot be true. Our version has a subterfuge taking place at the front door of the Thomas home on December 27th. The people's version, as reflected in the reports, read as if Mr. Thomas does not exist, as if nothing happened between the police officers and Mr. Thomas, and that their activities start at the front door with Mrs. Thomas when they knocked at the door, identified themselves, and politely served her with the subpoena, at which point she responded, "You chicken shits," quote, end quote. Now, we think the court has the power to quash the subpoena in this case because of the power inherent in the court to control the proceedings that take place before it. We also think that the court has the power to quash this subpoena based on the cases in which outrageous police misconduct took place and serious criminal charges have been dismissed or contraband has been suppressed. And we talked at one past appearance about the power to do the greater should include the power to do the lesser. It is our position that if the court, based on outrageous police misconduct, conduct which shocks the conscience of the court, has the power to dismiss charges and to suppress evidence, then certainly it has the power to do what we are asking, which is to quash the subpoena. We also think that the power of this court to suppress the subpoena comes by analogy to other cases where pretexts have been used and then condemned. Pretexts, for example, in the areas of traffic stops where they are used as a subterfuge to conduct searches for evidence of other crimes. We have pretextual vehicle impounding as an excuse to do an inventory, to rummage for evidence of other crimes. We have pretextual arrests where one arrest is made as a ruse to conduct a search for evidence of other crimes. All of those cases give this court the power to quash this subpoena because of the pretext that was used at the door of the Thomas home, namely asking Mr. Thomas to come outside in response to an investigation having to do with an auto burglary, a burglary of his vehicle. And when he disappeared with the officers, having them come back to the door in his absence, infer to Mrs. Thomas that her husband, her loved one, was either injured or dead, and she should come outside immediately, at which time they served her with the subpoena. We think that was outrageous. We think that all of these cases that condemn pretexts apply. And we think that if the court is looking for another reason to quash, some factor in addition to the improper service, then we can look to the fact that Mrs. Thomas has no relevant or material testimony to offer in this case. Now, in my paperwork, I have been supplied with reports that say, or that quote Mrs. Thomas as indicating that the defendant Simpson never hit me, never beat me, never abused me, never battered me. I don't think they would call her in their case to establish that. She also is quoted as saying, Mr. Simpson told me he was innocent and that he was being framed. I don't think that they would call her to testify to that. She also is quoted as saying, Mr. Simpson asked me to keep his younger children involved in the black church and in touch with the black side of their heritage. I don't think they would call her to testify to that. The only thing that I have been supplied with as coming close to any basis for calling her is a report covering an incident by that can be summarized as this. On some unknown date, about 20 years ago, a backup officer responded to an unknown address with unknown primary officers and took Mrs. Thomas Simpson at that time to an unknown location where she stayed for an unknown time. And that this backup officer, the one thing he is certain in the middle of all of those unknowns is that she, Mrs. Thomas, had no visible injuries. And I think that that is not relevant, that is not material, and that is no reason to have her come in here. The other thing that I would point out to the court, and you have this report attached to the people's response, is that it appears that on December 27th, which is the point in time that we should be testing when the subpoena was served, that the people did not have this information in their possession, because the notation in the bottom left corner indicates received 1/9/95. Now, if 1/9/95 means January 9th, 95, they did not have this on December 27th, 94, and I don't think I think a good argument could be made that this provides no basis whatsoever, and attaching it to these papers in opposition does not help you decide what relevant material information she had on December 27th. Now, I would ask the court to do the following. Observe that not one single deputy district attorney has attached an affidavit to these moving parties. And that is to their credit, I would submit, because these reports, which tend to justify this service, is a half-truth, a distortion, and misleading in the sense that it starts at the front door as if nothing had ever happened. I would ask the court to reject the invitation by the titles used in that police report as of chaplain officer so-and-so doing such and such, because those titles are misleading. And the titles that come to my mind are Reverend Jim Jones of the Jamestown Massacre and Reverend Jim Baker and other reverends that don't match the invitation that's being extended to this court by the use of the term chaplain. I would ask Your Honor to consider the incredible scenario that the people want you to swallow, which is this lady is in hiding, and they go up to the door and they knock on the door and they say, Ms. Thomas, police officers, would you please open the door? And this lady who is in hiding and who is in concealment opens the door and they give her the subpoena. That is not consistent with someone who is in hiding. Her response, however, "you chicken shits," is consistent with our version of the facts, which is they had lured her husband outside based on a lie about his vehicle being burglarized.
Let me ask you a question. My recollection of the civil code that deals with the service of subpoenas does allow a court to issue orders to allow police officers to even break and enter to serve subpoenas under the appropriate circumstances, where these officers apparently didn't resort to that.
You are correct, Your Honor, and the difference is gigantic, because what happens in the situation that you are touching on is that a detached, neutral magistrate, much like the magistrate with a search warrant, is given all of the information that they have. And that detached, neutral magistrate then decides whether or not there is sufficient cause to authorize these officers to break open the door in order to accomplish the service. There is no code, civil procedure, civil, criminal, penal, or any other code that allows the officers to do that without the evaluation of the detached, neutral magistrate. In this case, the people bypassed that magistrate, and they went out to the house. And what they did is traumatize Mrs. Thomas by inferring the injury to her husband. Now, there are cases which permit the police to say telegram, florist, FedEx, or some innocuous excuse in order to get the occupant to open the door. But there is no case that says you can create the stress and the tension and the climate of fear that was created in this case.
So you're analogizing to the intentional infliction of emotional harm cases.
Well, I would, except that sounds like she wants to sue somebody, and she is not interested in suing. What she wants is to be treated with the respect and dignity that she's entitled to. She's not a suspect. She's not a defendant. She has done nothing wrong except be the victim of a cruel hoax by these people. These reports, it's much like Watergate. Watergate started off as a second-rate burglary, and it reached a national scandal level because of the cover-up. These people did what they did at the door, and then they filed reports with you, not by any police officer who was involved, not by any deputy district attorney who was involved, and omitting all references to what happened between them and the husband, and then uses the term chaplain in order to invite you to attach some credibility to that. And then they attach a report that they apparently received in January to justify conduct in December. I think it's outrageous. I think that what they did is totally inconsistent with what they claim. They claim in these reports that she was not in hiding. Her response indicates that her husband had been tricked outside. And their reports, which indicate she was not in hiding, I would add, is totally contrary to the representations made by Mrs. Clark here on January 3rd when I filed these papers and I complained of this conduct, and Ms. Clark said on January 3rd at 9 o'clock, we had to do that because she was hiding from us. Thank you very much.
Ms. Lewis?
Thank you, Your Honor.
Good morning.
Good morning. Your Honor, in deciding whether the court should indeed quash the subpoena, there's only one relevant issue for the court to decide, and that is whether this witness has relevant and material information to offer. There is absolutely no authority for the proposition that the court can quash the subpoena on any ground other than that, and that was the gist of our responsive brief and the People versus Superior Court Long case, which indeed holds that that is the only means in which a subpoena for a witness can be quashed. The authority cited by counsel does not apply here. This morning I supplied the court and counsel with the Fabricant case, which indicates the Code of Civil Procedure, section 1987.1, has no application in criminal cases. That case squarely held that. In addition, I was going to remind the court, which the court already took note of Code of Civil Procedure, section 1988, which certainly carries with it a harsher manner of accomplishing service than anything that was nearly approached in this case, and that is to allow the sheriffs to go break down someone's door. Certainly if someone were going to suffer emotional distress as a result of being served with a subpoena, that would be the situation where that happens. Further, the case law that counsel cites with regard to outrageous governmental conduct has no application here. There's not a single statute or a single case that I'm aware of, and I looked to see whether that has ever been applied in this instance in terms of moving to quash a subpoena, and it has not. There is simply no authority for that. As long as counsel mentioned the idea of pretext stops, the evolution of that law, indeed, is that so long as the police act lawfully, it does not matter what was in their mind or what subjective thinking they had. In fact, I'm aware of the most recent pretext stop case by the Court of Appeal was People versus Todd, decided a couple of months ago, I believe, at 30 Cal. 4th, 617. I think that was the fourth advance sheet from now, or third advance sheet from now. At any rate, that has no application here either. That's not an analogous situation any more than the cases which dismiss based on government conduct is. So what the court really has to decide here, and all the court has to decide, is whether Marguerite Simpson Thomas has relevant and material information to offer in testimony. And she does. We know, first of all, that she was married to the defendant for 12 years, from the period of 1967 to 1979. And the police officer, who, by the way, I received information with regard to that police officer's knowledge before we got the report in hand. That police officer indicated that he had been out to that location of where the defendant was living with his first wife approximately 20 years prior to that, which would have been 1974, since the police officer's report is dated late 1994. And 1974 would have been squarely in the middle of the 1967 to 1979 years, during which Marguerite Simpson was married to the defendant Simpson. And he recalls it well enough to recall that she had claimed she had been hit and that she and the children were removed from the home. That is a significant event, especially when one considers that it took place 20 years ago. As the court is certainly aware, the evolution of the seriousness with which police respond to domestic violence calls has brought us to the point where there is a serious response. 20 years ago, I submit, there was not a serious response. So the fact that those children and the wife had to be removed from the home certainly lend credence to the importance of that incident.
When was that information made available to the prosecution? When did you become aware of that?
You know, I didn't make a note of the date, Your Honor. The officer who had that report brought it into the office at some time after that. I'm sorry, I didn't make note of the date that I became aware of it, but I did become aware of it before we actually got the report.
Mm-hmm. What is your response to Mr. Jones' argument that that information was not made available to the prosecution prior to the December 27th date of the service of the subpoena?
I think, though, I cannot honestly tell the court one way or the other. I think it was made available to us before then, but I'm not sure. At any rate, Your Honor, that is not
then let me ask you another question then. Let's excise then from the thought process of issuing a subpoena for her, what is there that's material then that's left?
There, in terms of her relevance in testimony,
yes.
There is a lot, Your Honor. She spoke to a police detective with the Robbery Homicide Division on June 23rd, 1994, and she had several things to say, which we, as the prosecution, feel it is incumbent upon us to investigate and to determine what can be gleaned from that information. Initially, she received a threatening phone call on her answering machine, which was made to, as she described, her unlisted home telephone number. And during that during that message that was left, the man who left the message threatened to kill her. Now, she was advised by Detective Harrow, I believe it was, of RHD, Robbery Homicide Division, to save that microcassette. We would like to talk to her about that. We would like to obtain that microcassette and do voice comparisons. Although Ms. Simpson-Thomas indicated that she did not recognize the voice on that tape, we as prosecutors would like to do some comparisons with known voices and see if they're...
Excuse me, Ms. Lewis, was that threatening phone call, the message, was it relevant to any of the facts and circumstances of this case?
Well, we don't know. The timing was very interesting that it happened on June 23rd, Your Honor, only 13 days or 10 days, 11 days after the murders in this case. So we need to find out exactly what is on that tape. We need to do comparisons. Part of the difficulty is in that, and I don't want to get into this factual dispute, but part of the difficulty was that Marguerite Simpson-Thomas was indeed evading contact with the district attorney's office, so we could not determine that in another manner. But of even greater salient relevance to this particular case was a conversation she had on June 17th with the defendant at Bob Kardashian's home in Encino. And she indicated to the police detective who interviewed her that the defendant Simpson asked her to go to his home on Rockingham. That's all the report indicates in that regard. We need to know why, for what purpose. This was hours before the defendant fled with Mr. Cowlings in the Ford Bronco, and after he knew he was going to be arrested. We want to know the details of that conversation. In addition, Your Honor, apparently she also spoke to Mr. Simpson when she did arrive at the Rockingham residence by cell phone. Apparently the defendant called her on a cell phone from the Bronco and spoke to her at that time. We would like to know the details of that conversation. These are all facts that could well be very important to the case. Now, recognizing that the court has made valiant attempts to limit both sides to only the one argument in cases, I want to address for a moment the idea that even if the court were to accept a notion that the court has the authority, even without statute or without case law in point, to dismiss the subpoena or to quash the subpoena based on outrageous governmental conduct, this declaration which Mr. Jones has provided, Your Honor, actually read more like, to me, a civil complaint for intentional or negligent infliction of emotional distress. I found it interesting that the court made a similar type of observation because it concentrates a great deal on Marguerite Simpson-Thomas's state of mind as a result of the alleged conduct. But what I want to do, and I want to make it crystal clear, that the allegations as set forth with regard to December 27th in Mr. Jones's declaration are not the way that it happened. And we can have a full-blown hearing and take up this court's time, despite having a sequestered jury, and ask the court to make that determination. But I do want to make it clear that we are not saying those facts happened. They did not happen. But I'd ask the court to treat that declaration sort of like a complaint in a civil case and a demurrer which is brought against it, and look at the allegations on their face, even accepting they're true. And again, I can't say it enough, especially with a camera and the way that non-lawyers understand these things, that it did not go down that way, and we have the investigators involved in it here prepared to testify, and we can take all the court's time the court, I'm sure, doesn't want to do in that regard. But if the court looks at the allegations that are made with regard to the conduct in Mr. Jones's declaration, all it alleges is that the police called the husband outside on a pretext, yelled something about her husband which caused her to open the door. It does not even indicate what it was that was yelled within the declaration, but yelled something about her husband which caused her to open the door and put their foot in the door long enough to throw a subpoena inside. And that's the end of the factual allegation. Then it talks about her mental state. So by implication, law enforcement left at that time. So what I'm suggesting, Your Honor, is that even if the court were to want to look beyond, want to look at the facts themselves, which the court need not do in this regard, as a matter of law, there is no outrageous governmental conduct, even under the allegations that Mr. Jones' declaration, which apparently is on information and belief, alleges. In fact, the trustworthiness of those allegations, it's inherently untrustworthy. Ms. Marguerite Thomas, when she appeared on the Barbara Walters show, indicated that the police had said there had been a rash of burglaries and for her husband to come outside and check. Even that is inconsistent with what's stated in this declaration, which was that the husband was told his car was burglarized. So But like I said, I don't want to get into a factual dispute because it's not important. It's a waste of this court's time and resources, and we're talking about a subpoena on a witness. We're not talking about something that goes to the defendant's guilt or innocence directly and should consume this court's time. But, Your Honor, the only issue that the case law allows this court to decide is whether indeed this witness has relevant and material information to offer. And for the reasons set forth, we certainly believe that she does. And consequently, we ask the court to deny the motion to quash the subpoena.
All right. Thank you, Ms. Wilson. Mr. Jones, do you have any brief response?
Very brief, Your Honor. Your Honor, counsel refers to some additional hearing sometime in the future. I've been here 3 times. It was my impression this is the hearing. If they have witnesses, if they have information, if they have documents, if they have Barbara Walters, then this is the time for it. We are asking the court to quash this subpoena. They say they need to investigate things. Well, the thirst for knowledge is admirable, but you don't do it by subpoena. It's the reverse. You do the investigation, you develop relevant and material information, and then you serve the witness with a subpoena. You cannot serve the witness with a subpoena and go fishing once she is on the stand, and I think that's ludicrous. Secondly, they talk about the weakness of our factual scenario. I would just submit it to the court that the response by this lady after this approach, knock, knock, police officers, Mrs. Thomas, may we come in, open the door, and she says, you chicken shits. That speaks volumes for what happened and where the truth lies with respect to this factual controversy. And lastly, this case that they gave me this morning says you can't assess fees after you quash the subpoena. I concede that. We're not requesting fees. We do ask the court to quash the subpoena.
All right. Thank you, counsel. All right. I accept the argument by Mr. Jones that the court does have inherent power to quash subpoenas in the face of outrageous conduct by either party in the service of a subpoena, although I have not been able to find any case authority that directly says so, but I accept that as a given, and I would be surprised if any appellate court would overturn that particular finding. In examining the assertions in the moving papers, however, I find that factually that the facts and circumstances in this situation do not rise to the level of outrage that would shock the conscience of the court. And so on that grounds, I decline to quash the subpoena. Then the court has to focus its attention to whether or not the witness has some relevant information with regards to this case. The fact that the witness on June the 17th did in fact have, or is alleged to have had, 2 telephone conversations with the defendant, and was, which relate both to the date of the arrest and the Rockingham residence. I find that that is a sufficient showing for the purpose of the issuance of a subpoena. So the motion to quash the subpoena is denied. All right, counsel, we had previously issued and held a body attachment for your client till today's date. Do you want to make her available on some date in the future, and I'll hold the warrant to that, hold the body attachment to that date?
Yes, Your Honor. I would appreciate being given a date by upon which the people intend to place Mrs. Thomas on the stand without any prior interviews.
All right, she's declining any prior interviews?
I beg your pardon?
She's going to decline to be interviewed pre-interview.
Absolutely. As a result of this treatment, she has no willingness to be interviewed by the people who were involved.
All right. Certainly.
I would add, she lives in Orange County, so I would appreciate a realistic date when they will put her on the stand.
Your Honor,
Well,
I just wanted...
I would suggest then that we place her, give us a relatively we'll get a date, and then we'll place her on call and make the arrangements through your office, Mr. Jones, if that's agreeable to you.
I will represent that we will cooperate and she will be here.
All right.
May I mention, Your Honor, that Ms. Thomas has been in the audience observing these proceedings quite a bit during the trial. It doesn't seem to have been a hardship for her to arrive from Orange County.
Well, as a matter, she's going to be here with her counsel as well, though, so knowing Mr. Jones's schedule as well, I'm willing to accommodate both Mr. Jones and the witness.
Tentatively for March 3rd, Your Honor.
March 3?
Mhm.
All right, March 3, body attachment will be issued, continue to be held until Friday, March 3 at 9 a.m. Thank you, counsel.
Thank you, Your Honor.
All right, record should reflect that we've been joined by the defendant, Mr. Simpson. Ms. Clark, are you prepared to call your next witness? All right. Mr. Cochran, anything else before we ask the jury to join us?
There's one other matter, but I think we can do it later. There's one other matter. I do have a question, Your Honor, that I'd like
Certainly.
I'd like to approach on without the board. That's good for weather.
I'm going to invite the jury to join us. All right, Deputy McNair, let's have the jury, please. Good morning, ladies and gentlemen. Ms. Clark, you may call your next witness. I'm sorry, Ms. Clark, what was the name? Eva Stein. Thank you. All right, Ms. Stein, would you come forward, please? Ms. Stein.
So you're calling me?
All right, Ms. Stein, would you step around council table here and stand over here by our computer projector?
Can you please raise your right hand? You do solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat in the witness stand and state and spell your first and last names for the record.
Eva Stein.
All right, have a seat, please, ma'am.
Okay.
All right, could you spell your name, please?
Eva Stein, Evastein.
Thank you, ma'am. Ms. Clark.
Good morning, Ms. Stein.
Good morning.
You a little nervous?
Yes, I am.
All right. Take a deep breath. I'm going to talk to you about where you were living on the day of June the 12th, 1994.
I was living on 873 South Bundy.
And do you know where that is in relationship to 875 South Bundy?
It's just north
Is
of
that right next
875.
door?
Yes, it's the building right next door.
And was there someone living there with you at the time?
Yes, my boyfriend,
And his name?
Lou Karp. Karpf.
To your left is 3 Ford. That's been marked as Peoples 26. Do you see the location I'm pointing to, the intersection of Dorothy and Bundy?
Yes, I do.
Okay, if this purple house, excuse me. If this red house here is 875 South Bundy, what would this blue house be?
That blue house would be 873 South Bundy.
Your residence?
Yes.
Now, your particular apartment at 873 South Bundy, did it face the street?
Yes, it was in the back of the condo unit, and it did face the street.
The street where cars drive back and forth? Or was it an alley?
Well, the bedroom the bedroom part faced the alley.
Okay. Jonathan? Can you look on your monitor next to you there? Thank you. Do you recognize the location shown there? Does that look familiar to you?
Well, it's the back alley of it's the back alley.
Now, directing your attention to the building that is on your right as you face the photograph with the lights on the balcony and a Jeep parked in the driveway. See what I'm talking about?
Well, I see a few cars parked in the driveway.
Okay, do you see one that's parked facing into the driveway?
Yes, I do.
Okay. If that was 875 South Bundy, where would your apartment have been in relation to that?
Well, it's right behind that where the lights are on.
I'm going to use a laser pointer. See that moving cross?
Yes, I do.
Okay, can you move it up, Jonathan? Would your building be right there, where that moving cross is shown?
Yes.
Okay. And so, do you have an entry that opens onto the alley there?
Yes, I do.
Is that the entrance that you use for your, that you used for your apartment back in June of '94?
That is the entrance that I used, yes. That is the garage entrance.
Excuse me, sir, which exhibit is this?
I'm sorry, Your Honor, is that People's 38?
People's 38? All right, and are we going to be able to preserve that particular mark?
Yes, Your Honor. We're going to print.
All right. Then the print will designate as People's 38A.
All right, now did you have an entry that opened onto Bundy as well?
Yes.
You printing? Okay. On the night of June the 12th, 1994, what time did you get home?
I got home later on in the afternoon.
And do you recall whether Louis Karp was home on that day?
No, he was not.
Do you know where he was?
He was visiting family in San Jose for the weekend.
And do you recall what time you went to bed that night?
I went to bed a couple of minutes before 10 o'clock.
Now, your bedroom, did your apartment have an upstairs and a downstairs?
Yes,
And where was the bedroom?
upstairs.
So when you went to bed, you went upstairs to go to bed?
Yes, I did.
Did something awaken you?
Yes.
What?
A very loud barking of dogs.
And what did you do when that loud barking woke you up?
Well, I was sleeping and I heard the dogs barking, and I tried to go back to sleep and I couldn't because the barking seemed to be very, very persistent, nonstop, and very, very loud, and it actually kept me from falling back to sleep.
Could you tell if it was one dog or two dogs?
Overruled.
When I had first awoken out of my sleep, it sounded like, it sounded like a few dogs.
Okay. Could it have been one? Could you tell?
Overruled. The way it's phrased, it's compound, however.
Sorry. Thank you, Your Honor. Could you tell for sure whether it was one or more dogs?
No.
Had you ever heard barking that loud and that insistent in the neighborhood before?
Not at that hour of the evening. It's a pretty quiet area, and I've never really heard, very much barking.
So the barking woke you up, and you couldn't go back to sleep?
No, I couldn't go back to sleep because it just was very unusually loud. It was just like a regular bark. It just seemed very like an insistent, loud bark, and it just didn't stop. And I remember being very annoyed because I couldn't fall back to sleep.
Could you tell, or did you have a sense of where that barking was coming from? What direction?
Well, facing, the alley from my bedroom, it seemed to be coming from the left, a distance down on the left side.
Okay, so if you were facing the alley, it would be to your left?
It would be to my left.
And would that be south of you?
Yes.
Can you look at your monitor? See where the cross is?
Yes, I do.
Would
Yes.
it be from that location that you heard the barking coming?
Pleading suggested, Your Honor, said distance down the alley. Objective.
Overruled.
And your answer was it coming from that area where you see the cross?
It seemed to be coming, yes, from that area, but further down.
How about there?
Almost from the end of the alley, like from where the street starts.
It seemed to be coming from...
That mark, Your Honor,
Well,
the alley was
excuse me, Your Honor. Could counsel allow me to question the
You
witness?
can do that on cross-examination if you like.
Counsel will have plenty of time, I'm sure.
Yep.
Could you, Jonathan, could you move it down farther, please? There we go. Tell us when to stop.
Yes, around that area.
All right. Could you put a circle there? All right. Now, that was a general sense of the direction?
That was the general sense, yes.
So it would have been to the south of where you were?
Yes.
At some point, did Mr. Karp get home?
Yes, he did.
When he did, was the dog still barking?
Yes, it was.
And when he got home, about how long was that after the dog barking woke you up?
It was approximately half an hour after I woke up.
How could you tell when Mr. Karp got home?
I asked him what time he came home the following day.
And he told you?
11:45.
So you began to hear the dog bark at approximately 10:15?
At approximately 10:15.
Now, did you see Mr. Karp when he got home that night?
Yes,
And when you saw him, where was that, upstairs or downstairs?
downstairs.
And did you see anything in his hands?
No.
Was the dog still barking at that point?
I don't remember.
Did you ever go back to sleep?
I did go back upstairs and I tried to go back to sleep. Kind of dozed in and out. Not really, fell back to sleep.
And why's that?
I just couldn't fall back to sleep.
Was there something preventing you from falling back to sleep?
I think just because I had been already up and was woken up, and Lou had come home, my boyfriend, and I went back to bed. I guess I was kind of like waiting for him to come up, and there was no other reason I could think of.
Was there any noise outside?
I don't remember.
Do you remember hearing the police arrive?
Yes, I do.
And was that, how long was that approximately after Lewis got home?
Well, Lewis stayed downstairs for a while and came up, close to midnight. And then sometime after midnight, I don't remember the exact time, is when I heard the police come and all the commotion in the alley, just from the police cars.
So it was sometime around midnight, after midnight?
After midnight.
And did you and Lewis have a conversation about a dog that he saw that night?
No.
Was it after that? Did he at some point tell you about a dog he saw that night?
Yes, the next day after we had found out what happened.
What did he tell you?
Sustained.
As of June the 12th, 1994, how long had you been living there?
Approximately a year.
And had you ever heard dog barking like that before?
Not in that intense way, no. I mean, I've heard dogs barking in the neighborhood, but not as intense as I heard it that evening, and non-stop like that.
Thank you, Ms. Stein.
Mr. Cochran?
Morning, Ms. Stein.
Good morning.
I'd like to ask you just a few questions, if I might. You lived at a house just north of the 875 South Bundy residence at 873, is that correct?
Yes, that is.
And as I understand your testimony, Ms. Stein, the bedroom window of your residence faces west, kind of looking over this alley we see depicted on People's 38, I guess. Is that correct?
Yes, the bedroom faces over the alley.
And you recall talking with the police in connection with what you'd observed on June 12, 1994, back on 11/9/94? Recall talking to the police officers?
I recall talking to two
to some police officers about what you'd observed?
At my work. They
Yes.
came to my work.
In fact, you talked with the investigating officers in this case, the detectives Lang and Van Adder, isn't that correct?
Yes, that's correct.
And they came to your place of work in the city of Vernon,
Yes,
and they spoke to you, is that correct?
yes,
And when you spoke to the officers, you, of course, tried to be as accurate as you could, is that correct?
yes,
And you told them what you recalled, is that correct?
yes,
And would I be correct in assuming that in November of 1994, the events were fresher in your mind at that time for things that had happened in June than they are now? Is that a fair statement?
I assume so.
All right. Now, when talking to Detectives Lang and Van Adder, you told them, did you not, that you went to sleep between 9:45 and about 10 o'clock, or strike that, that you got into bed by 9:45, between that and 10 o'clock, is that correct?
I don't recall saying I got into bed between 9:45 and 10 o'clock.
All right, well,
I recall saying that I went to sleep at approximately 10 o'clock.
all right, well, let me, if I might approach Your Honor, I'd like to show you, referring to page 1371. I'm just going to ask you just to review Circuit's report, if I might refresh your recollection. Will you read this first part to yourself? Why don't you read from here to here? Just read that part. Thank you. You read that now?
Yes.
Okay. And does that tend to refresh your recollection that you indicated to the police that you retired to the upstairs bedroom and went to sleep between 10:45 and 10 o'clock p.m. on June 12th?
It does not refresh my memory about the exact words that I used,
All right. Does that refresh your recollection?
of the exact words that I used.
Okay. But,
Speak yourself when you said between 10:45 and 10 o'clock.
I'm sorry, I perhaps did, Your Honor. I intended to say between 9:45, thank you, Your Honor, and 10 o'clock p.m. on June 12th. Does that refresh your recollection at all?
I remember saying that I went to sleep approximately 10 o'clock. I don't remember the exact words that I used.
Okay, so about 10 o'clock would be accurate.
Yes.
Okay. And when you went to sleep, you didn't hear any dogs barking at that point, did you?
No.
Okay. Now, did you then tell the police officers that sometime between 10:15 p.m. and 10:45 p.m., you were awakened by what you described as, quote, intense barking by a, quote, a few dogs?
Yes.
All right, and that's what you told them, isn't it?
Yes.
So sometime between 10:15 and 10:45, you're awakened by this intense barking by a few dogs, right?
Yes.
All right? And you went on to tell the police, did you not, that you had never heard this much barking of dogs in the neighborhood before that particular night.
That's
Is
correct.
that correct? All right. That after you were awakened, your fiancé, Mr. Karp, returned to the residence approximately 30 to 45 minutes after you were awakened by these barking dogs.
Correct.
Is that correct?
Yes, it is.
All right. He came upstairs and changed, and he went to bed ultimately. Is that right?
Yes.
All right. Now, at any time that evening, did you hear any screams or any sounds anywhere in that
No.
area? You never heard any screams or any sounds or anything?
No.
And these dogs that you heard barking, it's your best recollection, the sound of these dogs barking came somewhere south of your location, near the intersection of Dorothy and Bundy. Is that correct?
Yes, that's correct.
And, have a second. Sure. And the area here, you can see that on your monitor, can you? Where that circle is, that is where the general area where you believe that there was these barking dogs. Is that correct?
Yes, the general area.
And if you can tell from that location, if you can tell, is Dorothy somewhere right around in this area? that near the end of the street?
Yes,
All right, and that's about the location as you understood it.
yes.
Now, when you heard these barking dogs, the intensely barking dogs, you never got up and looked out the window, is that
No, I
correct?
did not.
And you never saw any of these dogs? did
No.
you? All right. And you have heard dogs barking in that neighborhood before, but not to this intensity, is that correct?
Right.
Do you know about what time it was that you became aware there was some activity in the alleyway behind your residence? You know what time it was?
You mean as far as the police getting
Yes,
there?
as far as the police.
I don't know the exact time.
All right.
I know that it was after midnight, but I do not know the exact time.
Sometime after midnight, is that correct? Did you get up and go look outside?
Yes, I did.
All right. You saw police cars out there?
I saw a police car downstairs, right.
All right. Did you see any other cars other than the police car?
No, just the police cars.
And you didn't
Actually,
talk?
one police car.
One police car? And you didn't talk to the police that night, did you?
No,
Did they come and try to talk with you the next morning at all?
no,
So it wasn't until November that you spoke to the police, is that right?
right.
And that's when Lang and Van Adder came out to talk to you at your place of business, is that right?
That's right.
As best you can tell, Mr. Karp came home from this trip to San Jose sometime between 10:50 p.m. and 11 o'clock p.m., isn't that correct?
I asked Mr. Karp what time he got home after we found out about the incident,
Yes, ma'am.
and he said that he came home at about 11:45,
All
is
right.
what he told me.
All right, so about 10:45 is your best thought.
Yes, according to what he told me.
And that was during the time that you'd been sleeping, is that correct?
Objection, you state the testimony.
Well, I'm asking. I'm stating testimony.
Overruled.
Had you been
Well, by the
asleep?
time he came home, I was already awake.
All right. So if you slept between 10:15 and 10:45 and were awakened by the barking dogs at 10:45, right? You're already awake, right?
I was awake when he
All right.
got home.
And have you seen his statement to the police about what time he arrived home?
No,
But it's your recollection that you were awake by the time he actually got in.
I was definitely awake by the time he was home. I had been awake for some time.
How long?
It seemed approximately a half an hour.
So could he have gotten home later? Perhaps 11:15?
I don't think so.
You didn't look at a clock, however.
The only time I looked at a clock is right before I went to sleep.
And that was at what time?
That was a few minutes before 10 o'clock.
All right. And that was the only time you looked at the
That was the only time.
clock? Okay. Thank you very kindly.
You're welcome.
Sure.
Thank you.
Thank you.
Ms. Clark, do you have any redirect?
So your most accurate statement of time is that you were awake for half an hour by the time Lewis came home.
Yes, approximately half an hour.
Felt like that.
It felt like that.
And you feel certain of that?
It just felt like about a half an hour.
And when he came home, that was half an hour after you heard the dog start barking.
Yes,
And then you learned that he came home at 10:45 approximately.
yes.
Overruled. Recross?
I have been further.
All right. Ma'am, thank you very much for coming in. Please don't discuss your testimony with any other person until after the case is over. However, you may discuss it further with the attorneys. All right? Thank you very much. All right, Ms. Clark, let me ask you a quick question. On the two hard copy printouts of the items that were circled, do you have one or two? We have two? All right, the 38A will be the cross by the up by the windows, I believe. And then 38B will be the circle down by the end of the alley.